I still to this
Yeah.
day am mystified in that Mila and Ashton did this, hostage video. Did you see this where they're apologizing? They did a little video, uh, low grade YouTube
Oh,
video apologizing for the letters that they wrote. And I'm here to tell you two, you have got nothing to apologize for.
right.
Could your letters have been done a little bit better? Yeah.
Oh,
And guess
yeah.
what?
But
But
that's
that's
different.
not their fault.
Correct. Correct.
You
Absolutely.
have
That is not their
nothing
fault.
to apologize for. Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey everybody, Doug Passon coming to you from Studio 3553. An early morning session with my good friend Mark Allenbaugh. What are we here to talk about today? The Danny Masterson sentencing. He was recently convicted of 2 counts of forcible rape, and his sentencing just happened. And if you've been paying attention, there was a massive to-do, brouhaha, uproar, whatever words you want to describe it. People went kind of ape shit over primarily the fact that there were sentencing letters submitted on his behalf. And particularly the ones from his famous friends Ashton, Kutcher, and Mila Kunis. There were a lot of celebrities in that stack of letters, but people went bananas because he got these letters submitted on his behalf, which sentencing letters is standard sentencing advocacy 101. We can talk about the efficacy of them, but it just struck me that we needed to dig into this and use it as a teaching moment. So my guest today, as I mentioned, a bona fide celebrity in his own
Yeah.
right, especially in the glitz and glamour world of sentencing statistics. Welcome back, Mark Allenbaugh. How are you, man?
Good morning, Doug. I'm doing well. How are you?
Good. I know we got to get this thing in the can and quick because apparently there's some sort of sporting event that's happening in the
Yeah,
not too distant future.
we're up
Um,
against Coach Prime in about an hour. So,
okay. So Mark and I have done a bunch of these episodes. We've called them sentencing post-mortems, where we take, particularly in high-profile cases, but we take sentencings like the Elizabeth Holmes or the Chrisleys, and we dissect them and see what we can learn about sentencing advocacy primarily, but kind of how the system works in general. We have a lot to learn from these cases. So I'm going to just throw it to you. Just initial thoughts, like what when you heard about this, when you saw like what's percolating to the top of your brain about some of the more important things we got to talk about today with this sentencing?
well, one of the things is that even though this is a state case as opposed to federal, and you and I usually speak about federal, with respect to sentencing, there's some universal principles, I guess you would say, in terms of advocacy and what works. With respect to California in particular, they have a different sentencing regime than the federal system, so the statistics and whatnot aren't as impactful or as necessary, but there's still some other issues that are universal. One of the things, though, is how the memorandum, and I'm sure you're going to speak to this too, but how the memorandum is presented. I mean, this was a high-profile case that went to trial. There was some very bad facts. From what I understood, at least 3 witnesses testified that they were raped by him, and there was a lot of corroborating evidence as well that was introduced. Obviously, he was convicted, so the jury was convinced beyond a reasonable doubt for sure.
Mm-hmm. Mm-hmm.
But the sentencing memorandum, which would have been the issue, actually, just to get down to it, what the issue really was at sentencing was whether the judge was going to give him 15 years to life with the possibility of him being paroled or getting a parole hearing. And unlike the federal level, California still has parole at around the 15-year mark. If I understand it, he had to serve at least 85% of
Yeah.
that 15 years before he would be eligible for parole. So around 12 and a half years, somewhere around there. And so that was the issue. Or because he was convicted of raping 2 of the 3 victims, I guess there was a hung jury on the 3rd, but because he was convicted of raping 2, the issue was whether those 2 15-year minimums would be stacked or the court would sentence them concurrent. And of course, Masterson's counsel was asking, requesting that the judge sentence him concurrently to those. That way he would be at least eligible for parole in around 12 and a half years. And the court denied that, primarily actually for legal reasons. The court said that the way the judge interpreted the statute, that she was required to sentence them consecutively because there were 2 independent rapes, but 2 different victims at 2 different times, 2 different, I guess, modus operandi.
Well, that said, though, because you were kind enough to pull the sentencing transcript and I read her comments, she did say that's her reading of the law, but she then went on to say that even if she could have given concurrent sentences, she wasn't going to, and followed up with a litany of a parade of horribles about his conduct that would have precluded that.
Right. So that told me right there, that sentence, right when she made that observation, like, look, I was going to give him consecutive anyway, even if I had the discretion to make it concurrent. That told me that there was a failure to communicate any mitigation. And the primary vehicle to communicate mitigation, as we know, is the sentencing memorandum. And the sentencing memorandum, as I was going through it, was very, very dry, it was very generic. I'll put it this way. It almost seemed like a copy and paste. And one of the things that I know that judges do not like, and I certainly do not like seeing, is when there is a host of character letters offered in support. And when there were here, that most of them are just reproduced within the body of the sentencing memo itself. The sentencing memo was about 26 pages, I believe. About 18 of those pages, 26 pages, 9 of those pages, so a good chunk, was just a cut and paste of big block quotes, not just like a phrase or anything, but big block quotes from the character letters. So that's the point of the sentencing memo, is for counsel to advocate, not just to regurgitate. And that's what I saw here, is just a bunch of regurgitation from character letters, and character letters that candidly were not very effective.
Well, let's dig into that, because I noticed that too. There are huge block quotes from all the letters, and the letters are attached to the memo as exhibits. So it's definitely redundant. I think some lawyers do that because they're worried that they've submitted so many character letters that a judge isn't going to read them all, so they have to include big chunks of them in the memo. And I guess the question is, if you're worried that you've submitted so many character letters that they're not all going to be read, then why are you submitting that many character letters in the first place?
Bingo. Exactly. That there could be overkill.
And that's one of the big takeaways. And we've talked about this before. Lawyers think that quantity is more important than quantity. And we saw this in Holmes, and we saw it in other cases, that like, oh goody, I've got 200 letters, that in and of itself has to be account for something. No, because most of these letters are at best sort of vanilla, don't add a lot to the story or the advocacy. And at worst, they do damage. I feel like we're going to have to do like Siskel and Ebert at this point, because we have gone Hollywood today. But that's a good analogy. Are you going to give this memo a thumbs up or a thumbs down? Clearly you're going to give it a thumbs down.
Thumbs down.
Yes. I don't know if I'm going to give this memo a thumbs down. And I agree with you wholeheartedly about the overuse of the quotes from letters. And I agree with you that there was a missed opportunity to tell the story, and that in and of itself is the most important part. But here's why I want to cut the lawyers some slack. They had a client who steadfastly maintained his innocence and went to trial and got convicted and stood before the judge at sentencing, still clinging to, adhering to, I am 100% innocent of this. I've been railroaded. These women are fabricating it to get money. For me, this is a grave injustice. So, as a lawyer at that point, you are hamstrung for the most important aspect of a mitigation story, which is to say, when I talk about my 3 R's of sentencing mitigation narratives, we talk about revelation stories, we talk about relativity stories, and we talk about redemption stories. And those revelation stories, the ones that sort of peel back the layers and reveal deeper truths about how a client got into the trouble that they're into, and not to explain or excuse it or justify it, but to give it context, and then to help then tell the story about, okay, this is how we got into this mess, and then we can move into the redemption story, hopefully, to show how they've tried to make amends for the
Yeah.
things that they've done, and ensure that they'd never happen again.
Right.
And so when you have a client that says, I didn't do this stuff, you don't get to do any of that. And you're automatically coming into sentencing with every strike against you because the judge is looking at you as a remorseless, unrepentant rapist who if you can't admit what you've done and come to terms with it and do the hard work to make sure it's never going to happen again, then not only are you a bad person, says the
Right.
judge,
Right.
but I'm going to be worried about you because you're going to do this. You're going to do this again. So now it's not just about, general deterrence where I have to show the public that this kind of behavior isn't tolerated. Now it's about specific deterrence. I have to take you out of
Yeah.
society for as long as possible because I'm terrified you're going to do this again. So,
Mhm.
so what do you do as a lawyer with that? You're left with two things: the relativity, which are comparing this to that, which I
Mhm.
don't think they did
None.
anything with. And I'd love
None.
to hear your
Zero.
take on that,
Yeah.
especially because there's a pretty big comparison to be made with a dude who's also sitting in prison right now by the name of Harvey
Mhm.
Weinstein,
Mhm.
who got 16 years in California courts for his rapes.
Right.
Um, but I don't know if you can do meaningful comparisons there or not. But
Sure you can.
I would have
Sure you
hired a
can.
Mark Allenbaugh to dig into the statistics to see how most people are treated, and is he getting better or worse treatment because he's Danny Masterson from that '70s show. None of that happened here.
Right.
Maybe they looked in, and maybe, I don't know, maybe they tried, maybe there wasn't good facts. And then, but then the redemption story, that's all they're left with. And the
Mhm.
redemption story isn't just what have I done to redeem myself from this horrible set of acts. It's what have I done in my life to show that I'm a worthy person.
Mhm.
And I
Well,
think that's
also,
all they were left with. And they
yeah,
did that. They worked very hard to do that. I don't know that they did it very
they
well.
didn't do it well. They didn't do it well. But I was just going to add, though, but there's more to the redemption story than just retrospective. There's also prospective. What,
Yes.
even if I'm maintaining my innocence, I can still tell the story to the court through myself, through counsel, as well as through these letters. What am I going to do in the future? What am I going to do with my time in prison? I'm going to prison. I'm going for a long time. How am I going to spend that time? What can I do, regardless of how I feel about whether this I'm a victim of the system, which the judge here was very clear to point out to Masterson that she doesn't consider him a victim of the system,
Yeah.
obviously. But nonetheless, he could still tell that story while maintaining his innocence. That, look, this is what I'm going to do when I go in, and have a story told through all the character letters about what the community, these alleged supporters of him, what they're going to do to support him while he is in, and most importantly, once he gets out. Even if it's a generation from now, if these people are still around, if they're still alive, we have a place for him.
Yeah.
And to hold him accountable to make sure that this doesn't happen again, or something like that, along
Mm-hmm.
those lines. And
Mm-hmm.
so that story wasn't told. So I go back to Judge Mark Bennett's famous article about allocution that he wrote in the Champion back in March of 2011, and he had 5 principles of how to allocute. But without going into them just yet, I look at character letters as an extension of allocution, and there needs to be a consistent theme between those, between the defendant's allocution and what the character letters are trying to convey. Because here the character letters weren't that, because what the there was very little, if any, character letters about his upbringing or any trauma he suffered, and there was just kind of tangential character letters. This is something that Alan Ellis always preaches about, by the way, about pointing to what good deeds did he do when nobody was looking.
Yeah.
And you know, that's something that I didn't see that at all. I saw some reference to good deeds, like, you know, he contributed his name or showed up for some fundraisers and stuff like that. You know, but
well, but even the ones I saw some other attempts at it, which
yeah.
even those were backfiring and really tone deaf. For example, I think the best example, I think, I mean, I think the best example is what a strong anti-drug advocate he was.
Exactly. So what does that have to do? He's a sex offender. He was convicted of rape. Who cares about?
Well, but wait a minute. It's worse than that.
Yeah.
He's convicted of rape by drugging his victims.
You see,
and they're saying how he was so great at keeping me off drugs, and he was always anti-drugs, and in Hollywood there's drugs everywhere, and he saved me and everything else. That's a perfect example of how something's going to blow up in your face. There's no good way, and I'm sure it's true what they're saying, but there's no good way to present that given the facts that you're up against.
Right.
And so by the way, yes,
a quick point before I forget that.
Yeah.
The measure of success here would have been if the judge said this at sentencing. If she said, "Look, I disagree with you on the law. I am required to sentence him consecutively. However, if I had the discretion, to sentence him concurrently, I would have, because of X, Y, and Z." And the X, Y, and Z would be the mitigators that were presented. But so that would have been the sign of, and that always is the sign of success and mitigation when the court cites to something that the defense presented. The court here did not cite to anything that the defense presented, other than shooting down all the defenses at trial. But in terms of mitigation, you know, I've seen it before many times, where the court will say, you know, I read this letter from so-and-so and this letter from so-and-so, and will cite to specific evidence that the defense has provided and say, look, you know, but for, and we see this in federal court a lot, you know, but for the mandatory minimum, I would have sentenced lower and stuff like that, but my hands are tied. And so that's still a success there, because that could help on appeal. And so obviously he's going to appeal here, but that was not clearly the case here. So you know, just like with doctors, the first rule is do no harm. And that's one of Judge Bennett's rules of allocution. Is sometimes you don't want to say anything, because all you can do, you don't want your client to say anything at allocution. All you can do is dig a hole. And here, I believe that's what happened, even though I don't think he allocated, because he's maintaining his innocence. But all these letters were so tone deaf, both with respect to developing mitigation as well as in the public sphere, that, as you noted, they completely backfired. And one of the things that I think this is a teaching moment with respect to character letters is a good character letter is going to acknowledge the seriousness of the offense. Look, I understand. I'm writing this. I understand that Danny Masterson has been convicted of rape. That is a very serious offense. I'm not going to avoid it in my letter. I'm going to hit it straight on. And I'm very disappointed in him, you know, and blah, 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 you know, whatever it is. But here's what I would like to share with the court and get specific. You know, this is what he did, for example, when nobody was looking. And this is how I am going to support him and hold him accountable in the future, so he has community support. And that's what a judge wants to hear. You know, rather than just, you know, he's a nice guy and he was a big brother to me. I mean, that is just empty, vacuous bullshit, frankly. and there was just page upon page upon page of that.
Yeah.
And these letters were
Well,
just redundant and
and
useless.
so there's a couple takeaways there. Well, first of all, I think if there's a link to Judge Bennett's article, it would be good to put that in the show notes at setforsentencing.com so people can grab that, because he is a great resource. I've been trying to get him on this podcast, by the way, but maybe it'll happen. But so that's one thing. Second thing is just takeaway. Lawyering is about leadership. And in my opinion, this whole discussion reflects, I'm sorry to say, I mean, I know the lawyers probably had a really, really hard job representing this client, especially after conviction and maintaining innocence, but there was a failure in leadership, because they should have had some editorial input and discretion over these letters. They could have taken these and helped shape whatever they could have done. Not, they could have done a better job on that. You mentioned also, they didn't tell a story about childhood trauma or anything else. Not only did they not tell that story, they really told this story of his idyllic childhood.
Exactly.
I didn't understand what was happening. I was like, when we got to the memo, we said relevant back, Mr. Section B, Mr. Masterson's relevant background and procedural history, and then it says childhood in big bold letters, and I was ready to be like, okay, here we go. We're gonna get to something. And what was it? It was, he had a great childhood, but then there was a divorce, and then I'm like, okay, here we go. And there's terrible divorce, horrible family. No, the husband and wife stayed on good terms. Dad was still very active in his life, close relationship. Everything's wonderful. Then he becomes a child actor, and I'm like, okay, now here we go. Nope, he loved it. Everything was good. He got 150 commercials. Mom took good care of him, protected him. A bio dad's still in the picture, and there's a new dad, and blah blah blah. The only teeny little bump in the road that they said is when Mom had a second divorce, and then Danny had to be a quote unquote father figure for a mentor, protector, friend to his sibling. I'm like, okay.
They just painted a very privileged, wealthy, perhaps conceited individual that perfectly fits the narrative of a rapist. Somebody just
and on that note, my favorite part, and I hate that I'm laughing about this, but it's so fucking absurd, is after these allegations came out, his career was devastated and he lost his job. And so this poor guy was forced to purchase a ranch and plant a vineyard and start making wine. And in Santa Ynez, I don't know California that well, but how much do you think 6 acres of land in Santa Ynez and 600 vines?
Poor guy,
and he toiled in the fields day and night this thing. Like, really? That's the suffering that he's gone through, that he had to go out into this beautiful countryside and start a winery. That's what fucking filthy rich people do.
Right, exactly. Well, look, that's what they do as a second act. That's what they do in retirement. Yeah, so just sounded like he went into retirement. But look, what should they have done?
Still getting residual checks out the ass for that 70s show and everything else. And I just Googled him for the fun of it, and who knows, but his net worth is depending on who you read, $8 to $20 million at this very moment. So you really want to tell a story about his hardship for losing his work and his business and having to toil in the fields? Like some poor migrant worker. So tone deaf, so goddamn. It was such bad judgment. I'm sorry.
So do you still give it a thumbs up?
No, I guess I just felt bad because I know I've been that lawyer in that situation, and it is a very situation. But no, I don't. I give it a 2 thumbs down because even when you're forced to eat a shit sandwich, you can still sprinkle some sugar on it.
Well, let's talk about the sugar then. Let's talk about what they should have done. Okay. So we kind of mentioned it earlier. Well, first thing, obviously, and one thing that they did do right, at least a bare minimum, is argue the law. And they made a colorful argument about why the sentences should have been concurrent. So that was good. But in terms of mitigation, as we were discussing, they just completely blew it. So one of the
Yeah.
things that we mentioned earlier is comparative sentencing. They could have looked at Weinstein and other high profile cases where the
Yes.
facts ostensibly or arguably were a lot worse and the sentence was a lot lower. And, they could have gone to, the California's, I can't remember the name of the agency, but it's the equivalent of the Sentencing Commission, and obtain data from there.
Yeah.
I actually have done that in the past in the case. So I know the data is available, even though it's hard. You can't really find it online, but you can go there and get sentencing data and do a comparison on what other types of sentences were for this type of offense. Even if the judge's hands were tied, is how the court read the law that she was required to give consecutive. It would have been great to get a statement in there like, my hands are tied, but based upon all the evidence, I would have gone concurrent if I could have. That would have been a home run. That would have been helpful.
Yeah. Well, I can keep going with you because there's
Okay.
I had a whole list of things that
Yeah.
probably could have been done that were not done or were not done well, and you just rattled off a bunch of them. But
Wow.
one of the things you talk about repeatedly all the time, life expectancy.
Yes. So I got a chart. That's
Uh-huh.
what it was.
Yeah.
So let me bring that up. Let me bring that up here.
This is why we're such a good team.
Yes.
You complete me, or I complete you.
Right.
Just
So
to weave in as many Hollywood movie references as we can to this episode.
there you go. There you go. So here's the Masterson life expectancy chart. So for your viewers out there, Dr. Patterson, out of the I think it was SUNY Albany or something like, I can't remember what university she was affiliated with, but back in 10 years ago, did a very comprehensive peer-reviewed study on the life expectancy of inmates serving long terms of imprisonment.
Yeah.
And what she found was, and this was very comprehensive, again, peer-reviewed and all this other stuff, and it's been cited repeatedly in federal courts and state courts, but what she found was that on average, inmates can expect to lose 2 years of their life expectancy for every year of imprisonment. And she found this empirically. The Department of Justice, U.S. Department of Justice, has not gone and done such a comprehensive finding, but they, in several of their reports, they have alluded to, or actually they have stated the same, that an inmate's life expectancy is definitely lowered the longer the person is in prison.
Yeah.
So what I did is, if you lose 2 years so what we're looking at here, for those viewers that are watching on YouTube, is a chart that represents that right now in 2023, Masterson is 47 and a half years old. So according to the Social Security Administration, he has a life expectancy of 81.8 years as of today. Okay. So if he's going to lose a year of life expectancy for every year he's imprisoned, what that means is he's only going to make it around 12 years. He statistically will die sometime around 2034 and 2035 in prison. Because he was sentenced consecutively, the earliest he's going to be eligible for parole isn't until sometime in 2048. He will be long dead since then. So this would have been helpful to the court. Even if the court's hands were tied, this would have been helpful to the court. It's like, look, you're going to give him a life sentence no matter what. So, as we would say at the federal level, this is not a parsimonious sentence. It's far greater than necessary to meet the purposes of punishment here. Because if you want to take this guy off the street for the rest of his life, if that's what you're trying to do here, well, you are even at a concurrent level. And so this would have helped.
Yes.
But
so couple nobody called you. And that would have, okay, so there's two things. One is, let me just riff on what you just said, which is the goals of punishment. First of all, I got to point out how this sentencing memo starts, the very first sentence, because I always say start with a bang and end with a bang. This sentence says, in determining sentencing, the court should keep in mind the primary goals of sentencing in the criminal justice system: punishment, deterrent, and rehabilitation.
Like, really? No judge knows that.
Right. And judges love to be told what they should keep in mind. But you talk about the length of time that he's going to serve, and there are also studies out there about one of the goals of deterrence. And the idea of punishment is that what these studies say is when it comes to general deterrence,
Mm.
to the extent that's a thing. Oh, I saw this man got convicted of rape. I shouldn't rape someone because
Yeah.
I'll be in trouble like he's in trouble. What the studies tell you is it's the what? The certainty of punishment, not the severity. So you don't need to give this guy 30 years to meet the goal of general deterrence. It's the certainty of punishment. And how much more certain does a case than a case like this, where it happened 20 years ago? And the message is, I don't care if it happened 20 years ago, you're never going to escape justice. Retribution will come. The certainty is baked in the cake in this case.
Well, I think the studies that I've seen, it's not so much the certainty of punishment, it's the certainty of getting caught that serves as the deterrent. Because for the studies I've seen, potential offenders aren't going out there Googling and doing research like, how much time am I going to get for doing this particular offense? No, it's whether can I get away with it.
Yes.
So that is the utilitarian analysis that they give, if they give any. Sometimes
but logically the consequences flow from the catching. In other words,
right.
Am I going to get away with this crime?
Right.
And if I'm going to get caught, what are all the consequences that flow from that? Along with the life expectancy, why is life expectancy reduced because of incarceration?
Because of the terrible conditions of confinement, which is even worse for sex offenders.
Exactly.
And
there was a huge missed opportunity here when we engage prison experts like Walt Pavlo, Maureen Baird, Jan Purdue, the folks at Prisonology, to say, Judge, you want to talk about punishment? Let's look at what every minute of every hour of every day of every week of every month of every year is going to look like for Danny Masterson, a famous, relatively small in stature, wealthy, pretty boy actor convicted of multiple rapes.
Right.
Where is he going to serve his time? What prison do you think he's going to go to? Because I don't think they have little country club camps. Not that they have them in the feds anymore either. But he's going to probably go to a high security prison where who are the lowest offenders on the prison hierarchy? Totem pole.
Offenders.
Sex offenders. Right.
But also he has it worse because he's like an aggravated sex offender for purposes of how other inmates are going to view him, because he's so high profile. I mean, he's not just a sex offender, he's Danny Masterson.
Yeah.
And so he's going to be a big target. And so he is going to be very susceptible to abuse.
And that's a relativity story, comparing this to that. What is his sentence punishment going to look like compared to a more typically situated inmate? And the fact is, his punishment is going to be exponentially greater than someone else. So, 15 years of that becomes much more palatable if you look at it through these different sort of lenses.
Right. Exactly.
Missed opportunity.
Another missed opportunity. Another missed opportunity for sure.
And
go ahead. Well, I was going to say, did Masterson write a letter to the judge?
I didn't see one attached to the memo.
Yeah.
And what I don't know if he spoke, if he allocated in court on the day of sentencing.
Yeah, either. I don't think he did.
It would make sense that he didn't give.
Yeah, it would make sense that he didn't. I mean, you wouldn't see that here. But I thought there was some quote that from him, maybe somewhere. At any rate, it doesn't matter. It's a minor point. But go ahead.
Yeah.
I do want to talk about the victim statements and how those victim statements can be used as a model for character letters.
Okay, good. Well, I'll just finish my list because of things I saw in there that could have been done at all or done better, which is there was 4 sentences about his medical problems.
Yeah.
And one of the things I didn't even know what it was, and they didn't define it. He had chronic rhinitis. I should have Googled it. And then he has hives. So he breaks out in hives. But the point is it was 6 lines.
Mm,
And so what? They
yeah,
didn't either. It's really minor, in which case, why are you bringing it up at all?
right.
Who cares?
Yeah,
Or there's a real, it's going to cause him a real hardship. So you need to tell me what the fuck is chronic rhinitis? What does
yeah.
that do? What is the medical care situation inside? You need an expert for that. And how will
Rhinitis
that
is a runny nose.
really?
Yes,
They they put that he gets runny noses in a
they put that he
sentencing
gets runny
memo?
noses. Yes, rhinitis. This is from Johns Hopkins. Rhinitis is when a reaction occurs that causes nasal congestion, runny nose, sneezing, and itching.
I don't know whether to laugh or cry about that.
Yeah, that's pretty bad.
That's
That's so.
that's dude, that's even more traumatic than him having to start a winery.
Mm,
So he gets runny nose and
yeah,
hives.
yeah,
Okay. So I would say maybe you could leave that out of your sentencing memo then, because I'm pretty
yeah.
sure that the judge isn't too concerned about a runny nose and hives.
No,
Okay, so maybe they didn't have anything good to say there. Then don't say it at all. And then I
exactly.
think the last thing is they really did stress this, and a lot in the letters is the impact on his family. It's
Yeah.
being taken away from his family. What do you think about that?
Well, you have to know this goes back to Judge Bennett's article on allocution. You really got to know the message, and you have to know the context of the offense. I think this is a good segue into the victim impact statements that were read in open court, because both victims state in very emotional and powerful terms how this is a life sentence for them, being a victim of a sexual assault. So when the defendant brings up the collateral consequences that his wife is going to have to tend to the vineyard now without him, tone deaf is not even, doesn't even reach it. I mean, that they would even mention this goes, do no harm. Bringing up these trivialities in the context of this case, maybe that might work in a money laundering case or a fraud case or something like that, a non-violent offense. But here, no, I think that just exacerbates the harm and reinforces the lack of contrition, because of all of um, these letters, and defense counsel are saying, but judge, look at the harm to his wife. And well, what about the victims?
Yeah.
And let me hear from the victims. It just exacerbates that. It makes it even look worse, and because of the tone deafness of these
Yeah.
messages. There was no context here, or tone deafness, I should say, nothing but tone deafness.
Well, I have mixed emotions about talking about the family. I wasn't really focused on the wife. Now, I will point out a lot of the memo that we had our hands on was redacted when it came to Mr. Masterson's wife and daughter, I believe.
Mm,
And so I don't know what the full story is there. Generally, I mean, lawyers know, defense lawyers know it's dangerous territory
yes.
under ordinary circumstances, primarily because nobody ever wants to think you're using a child to manipulate a judge's decision.
Mm,
That's gross.
mm,
Moreover, most of the time, the kids or the wife were in the picture when the crimes were committed. So the standard response by the judge is, don't talk to me
right,
about that. You
right.
should have thought of that
They're just
when you
victims of
did.
your conduct too.
Yeah.
Yeah.
But the truth is, the wife and child come long after the allegations and the
Yeah.
conduct, and so they are unfortunately victims of this
Yeah.
case now
Yeah.
too.
Yeah.
And depending on what the seriousness is of the issues there, because yeah, they're financially going to be set, the
Mhm.
vineyard's going to be fine, they've got support up the yin yang.
Yep.
I didn't even notice. I was looking at, I think it was Billy Baldwin's character letter that he wrote, one of the Baldwin brothers, and
Mhm.
he's married to China Phillips. I didn't know that, but
Mm.
China and Bijou Phillips are sisters, and Bijou is, of course, the wife, Danny
Mm.
Masterson's wife. So the point is, they have so much support among these rich and famous Hollywood friends.
Yeah.
Financially, they're going to be better than fine, better than most any other individual on the planet.
Yeah.
And so the question is, emotionally, what is the fallout going to be? And if there's a story to tell there, especially with a child, maybe she has special needs or something else, I think you do tell that story. There's a way to tell it right. So I don't
Well,
know.
you're right, because and we've done this before, but it's in context. If it's somebody, if it's a child with special needs, and it's not a violent offense here, and we're talking about, an economic offense, and the defendant is the primary or sole caretaker of this child with special needs, and there's no financial resources or support system, definitely you would note that to the court, because that can be a significant mitigator. I mean, at least at the federal level, even the U.S. Sentencing Commission recognizes that as a possible mitigator. But here in context, though, I don't think you tell that story, because even if this child is suffering from some terrible, debilitating, chronic illness, or malformation, or had an accident or something like that, they have the means to take care of this child, and this child is not dependent on Danny Masterson. Whatever this child is going to lose in terms of a father figure, well, that's Masterson's fault, and he's just victimized his children and his wife. But I don't think it serves as a good mitigating ground here, and could also backfire, because using a child to try to manipulate the judge
Yeah.
here.
Yeah.
I just think the upside is so, in the context of this case, the upside is so small, really negligible, and the
Mm-hmm.
downside so big. I would not have raised it. I would
Mm-hmm.
not have raised the wife. I would not have raised. I think at the end of the day, before we get to the victim statements, but at the end of the day, I just would have focused on the law, comparative statistics, and life expectancy, and onerous conditions of confinement. Those would
Mm-hmm.
be the four, and that's it. I would not
Mm-hmm.
gotten into his childhood or any of this other stuff, because first of all, it's not going to explain it away unless he was the victim of rape. That would be the only thing that I think may have been relevant here, because we do see that, unfortunately, that many sex offenders, they themselves have been victimized repeatedly as
Yeah.
children,
Right.
and into the adulthood.
Yeah.
And so that might explain some of the conduct here, but that is not the case
Yeah.
here. So
Right.
and I think all these victim letters, or not victim letters, these character letters, did nothing but highlight to the court that this guy doesn't get how serious this conduct is, nor his defense counsel. So if the court was to give any consideration to sentencing him concurrently, that completely went out the door. And I think that's why the court, one of the things that the judge did say that's worth stating here, and I think it's kind of a rebuke, really, of the defense strategy at sentencing, was this. Towards the beginning of the sentencing hearing, the court says, Mr. Masterson, you are not the victim here. Your actions 20 years ago took away another person's voice and choice. Your
Mm-hmm.
actions 20 years ago were criminal, and that is why you are here. Ultimately, one way or another, you will have to come to terms with both your prior actions and the subsequent consequences. To quote Martin Luther King, the ultimate weakness of violence is that it is a descending spiral begetting the very thing it seeks to destroy.
Yeah.
That, when I read that, it was just, holy shit. I mean,
Yeah.
this judge was not buying. I think she was aggravated, frankly. I think she was
Yeah.
aggravated about the defense approach towards mitigation here. Their mitigation strategy backfired, and it was aggravation.
I just had a weird random thought. What would
Yeah.
be so helpful for us as defense attorneys if there was some way you could bifurcate, not necessarily bifurcate, but basically litigate the appeal of the trial before you had to present a full sentence? Wouldn't it have been so nice? Because everything they're doing now is saying, well, we may have appeal issues. This case is coming back on appeal, so we can't go before the court, fall on our sword, admit
Right.
everything, express remorse, and do that dance, because if this case comes back on appeal, we are
Yeah.
in
Right.
toast. We're done.
Right. Right.
And so it's the system really ties your hands in the way that this works. Wouldn't it be in a dream world to be able to say, we're gonna appeal the trial, and then you lose the appeal and you realize you have no issues. Now let's talk about sentencing, and a defendant can be free to go in there and do the real work, you know, to tell their story and to express appropriate level of remorse and do everything they need to do.
Now that I know I'm really wrong.
Now that I know I have
Now,
no hope
right,
of
now I have
having
no
this
hope,
case. Yeah,
I
mean,
guess. I mean, I guess, but I mean, that's kind of what they should have done here. I would have avoided all of this weak sauce
yeah,
backfired attempt at mitigation
yes,
in this case, because he went to trial and he's maintaining his
sure,
innocence. And I would have focused on the science and the law. That's what I would have done.
yeah,
Science and law. That's it.
yeah. So
Science, law, and prison conditions of confinement.
you had more to say than on the victim statements, yeah?
Yes. So let's look at the victim statement here. There were two different victims. I'm not putting their names up, even though they're public record. Let me just get it up here. Again, it's a teaching moment. I mean, I'm not trying to pass judgment on Masterson or the victims or anybody here, other than, you know, and I'm not even passing judgment on defense counsel. I'm just passing judgment on the work product.
Yeah.
So, you know, because I'm sure I know
That's
defense
what we're
counsel is
doing
very, very
here.
competent.
It's all teachable moments.
Yeah, it's all teachable moments. So here, the way this was written, and it's much longer than this. This is just an excerpt, but the way this passage is written, it is so powerful, well written, specific, and it draws you in. That is what a good character letter should do. Well written, specific events, and it draws the reader, in this case, the judge, in, and it reveals something specific about the writer, him or herself, rather than just, you know,
Yeah.
Danny Masterson's a nice guy.
Mm-hmm.
You know, that's just so. And this is, and it goes to the offense conduct too. It speaks specifically to the offense conduct.
Yeah.
Here it starts. When you're raped, this is one from one of the victims. When you're raped, it's not your surface that's most defiled. It damages you on a cellular level. I honestly still don't even have the words to properly describe what being raped does to you. I just know the symptoms. I've suffered insomnia. I would oftentimes stay awake for 24-hour periods. I hate the dark. I cannot sleep next to anyone. And then just skipping forward, I harm myself in my sleep. I mean, I regularly wake up with deep bruises and scratches on my hands and arms. This is what defense counsel needs to be aware of, especially in sex offense cases, is be cognizant of the victim. You know,
I'm always fighting monsters. I punched a hole in the wall behind my bed during my sleep.
Yes. So you know, probably what a good exercise would be to tell those who are writing character letters in support, when you're writing that letter, pretend the victim, if there's an identifiable victim of the crime, especially in sex offense cases, but pretend the victim is sitting right next to you when you're writing that letter.
Yeah.
You know, I think because and the reason why is I think I can see some listeners saying, well, why the hell would you want to do that, Mark? That's going to take away from the effect and the power. No, it's not.
Yeah.
Because your letter is going to come across as more authentic now.
Right.
That you're taking into consideration the offense conduct and the victim and what happened to the victim too. And you're not just ignoring it or blindsiding it and making it an empty exercise, which is anything but what a character letter should be, because that might be the only thing that could save or help the defendant are these character letters.
Yes.
So here's what I'm sorry, just real quick. So this is the other victim, just to get through this. So let me see. This goes to the lasting effects of the offense conduct. So healing is not something linear. It's not a simple thing. The lasting effects of rape are pernicious as they hack silently away at the daily efforts one tried to make toward a life with meaning. Do not confuse it. Even though it was so long ago, what you did to me by emotionally, mentally, and physically injuring me in this brutal manner still reverberates and lives on in my body as corporeal pain. The body is a relentless witness.
Wow.
Jesus.
Yeah. That's a great, I mean,
That's how you write a
that's
character
how you,
letter too.
right, right. With that amount of emotion and
Yes.
detail, specificity, which of course
Yes.
builds credibility,
Correct.
it's very hard to say that anyone's fabricating when they give this granular detail about the trauma that they're suffering.
Right.
And so, you know, and I will say that, you know, some people may be listening to this who would say, well, then, yeah, why would you even represent these horrible monsters who inflicted this much pain and trauma and everything else? And the point is, listen, you know, people do horrible things. They have to suffer consequences. We're only saying what is an appropriate consequence when you know what the truth of the life in prison is going to be and how many lives are ruined as a result. And I would have no trouble standing up and saying 15 years is an absolute just result,
Yeah.
even in the face of the horrible trauma that these victims have suffered,
Right.
because our system can be overly punitive. So it's not about whether he deserves punishment or not. It's just
Right.
about what is justice. And the problem that I have here, especially when it comes to the public's outrage,
Mm.
is that I love to talk about the three R's of sentencing,
Yeah.
narrative, and everything
Yes.
else. Well, in this case, there was only one R, and it was
Mm.
rape.
Right.
In other
Yeah.
words, that's the beginning and the end of the story for
Right.
Danny Masterson. He did this horrible thing. That's all I care about. That's all I need to know. And that
Mm.
is not how our system is supposed to work.
Yeah.
People need to understand that you, as horrible of an offense as a person commit, your goal is to judge the person as much as the crime.
Mm.
And the person isn't supposed to be defined only by their worst actions in life.
Mm.
Yes, he committed horrible crimes. Yes, he must be punished severely, but to simply write him off as a monster that needs to be locked up forever is inhumane. In other words,
Yeah.
he did this, but maybe that's the beginning of the story, not the end of the story.
Right.
And we've already talked about the fact that they didn't develop the rest of the story, but the bottom line is
Mm.
the rest of the story matters. And for the people to just say, well, he did this and lock him up forever, that's not how this is supposed to work. I'm sorry. That's not.
Well,
Maybe
basically
if
they
you
did though,
maybe if you
but
go into a school and shoot a bunch of children and murder, 20 children, yeah, that's it. End of story. There's not anything else we really need to say here, unless it's a death penalty case, in which
yeah.
case that's a whole other story. But you see
Yeah.
what I'm saying here,
Yeah. Well,
right?
this is a
Yeah,
but Doug, this is a death penalty case. That he got
yeah,
sentenced to death by prison.
yeah.
And
Well, and that's my point.
yeah.
This you have to treat every one of these cases as a
Yeah.
death penalty case, because he's going to spend the rest of his life in there.
Right.
And a person is worthy of having their story told. And this is where I want to stand up in defense of Ashton Kutcher and Mila Kunis and every other one of these 50, 60, 70, 80 people who wrote sentencing letters.
Yeah.
The fact that they took so much shit, and it wasn't even, from what I could tell, it wasn't even a lot of shit they took because of what they said in the letters or how somewhat tone deaf some of these letters were. It was just the fact that they wrote
You're right.
the
Right.
letter,
Right.
that
Right.
they stood by the side of a man who was convicted of rape.
Right. And and you're right. It is, well, I'd say it's unfortunate for the public feedback, but you know what? That's part of that's part of it. If you're going to write a letter for somebody, I mean, you have to expect some, especially somebody high profile, you have to expect that. And so I cannot, I cannot say that the public was wrong for the feedback it gave, but rather what I would say is, be courageous. If you're going to write a letter for somebody, that a friend of yours or a loved one that did something fucking awful, you have to have courage too. And you're going to have to be prepared. So this is what it comes down to: is counsel needs to prepare people better for writing character letters. If there's nothing else, if there's not a better takeaway from this, it's that. I mean, I want any attorney out there that is involved in sentencing, that has that submits character letters or
Yeah.
solicits character letters on behalf of their client, you got to tell them what to write. don't
Yeah.
coach them, don't write it for them. That's not what I'm
Right.
saying. But this is there are many. I mean, you could just Google it. There are many law firms out there. Alan Ellis has a great article about how to write character letters. I encourage everybody. We'll put in the show notes to read
Yeah.
Bennett's article about allocution, because I think the character letters are part of allocution. But just like you should know what your client's going to say if he decides to allocute, and sound, well, you probably don't want to say that, and you
Yeah.
probably should mention this. Just
Right.
like that, you practice elocution.
Right.
You need to do the same thing with anybody
Well,
that's writing a character letter, so it doesn't go, so it's
yeah.
not tone deaf.
Well, and it starts okay, so you make a great point, and it's lawyering is leadership. So you need
Yes,
to take
exactly.
the lead, but it also starts with the narrative, it starts with the story. Before you get to the character letters, you
Bingo.
want to develop a solid mitigation narrative, and then you give them the roadmap of what we're trying to accomplish here. I'm actually working on a character letter article too with my friend and colleague, awesome attorney Patrick Barone, who's been on the podcast. And as you know, Patrick is swims in the waters of psychodrama, and that's very much about empathy and what you talked about, which is you have to see the world now through the victim's eyes and live their experience, so that you can write a character letter that doesn't come off as tone deaf or offensive, that resonates. And so there's so much work that goes into this, but the bottom line, I think, again, standing up for these people, you if you were convicted, anyone who's listening to this, any person on the planet, if you found yourself in the unfortunate, terrible situation that Danny Masterson finds himself in, you would want that. You'd want it for your father, your brother, your son, even if they were this damaged, and even if they did these kinds of terrible things. You would want to understand that, yes, punishment is coming, it's inevitable, but you would want the person that you care about, you'd want the person deciding their fate to know the full picture of the human being that did these things. So I say kudos to fucking Kutcher and Kunis and everybody else for speaking their truth, especially because they're public figures. And for the most part, I'm reading these letters and I want to dig into just some of the specifics, because it didn't come off to me like they're totally discounting the pain of the victim or the seriousness of the offense. It was just focused on their friend, and they had something to say about the man they knew very well, and they were brave enough to speak their truth. Consequences be damned. I still, to this day, am mystified in that Mila and Ashton did this, hostage video. Did you see this where they're apologizing? They did a little video, low grade YouTube video, apologizing for the letters that they wrote. And I'm here to tell you two, you have got nothing to apologize for.
Right. No, I agree with that. They have nothing to apologize for. Yeah.
Nobody has anything to apologize for. Could your letters have been done a little bit better? Yeah. And guess what? That's not their fault.
Correct. Absolutely.
You have nothing to apologize for.
And this goes back to leadership. And these are teachable moments. And I think, and I just will leave your audience with this. I think character letters are exceedingly important, and they can sway a judge, and judges do read them. But first of all, quality over quantity, and counsel needs to be to look these over before submitting them, and give the writers an idea, a theme. Hey, here's what we're going for. Here's what we're focusing on. Here's what we need. Give them a theme, and let them know we want specificity, right from the heart, and things of that nature. And quality over quantity, always.
And when you can't tell the story of the offense, there are lots of other important stories you can tell, and we talked about them today. By the way, before you go, plug the new website, because I always say go to sentencingstats.com, but we're handling a ton of 0-point offender cases and sentencing. So what's that?
0pointoffender.com or amendment821.com.
All right.
You can go there and just plug in some data from your case, and we do a little calculation for free there to let you know if it looks like your client or you would qualify for the 0-point offender adjustment.
And if you want to know what the fuck we're talking about with 0 Point Offender, go to setforsentencing.com, because we've done at least 2 podcasts on the new amendments to the sentencing guidelines, and they are retroactive and they are coming down the pike fast. So go enjoy your game, man. I'll talk to you soon. Thanks for spending the morning with Danny Masterson. Take it easy.
Okay. Thanks, Doug.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassenlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.